Question, can you still copyright a song with a leased beat even though other people are using the same track? Yes. So the way it works is that you have to disclaim when you are filing. You say what are the parts of the song that's owned by someone else. And so you need to put in and say the instrumental or whatever. And that's in the actual application. So you own all the new things in your version of the song. But if you don't have the right of ownership to the leased beat, you just say that in the registration. So we do that kind of thing for cover songs. We do that kind of thing for remixes. So you definitely can still get your copyright protection, but obviously you can't copyright the thing that you don't own.
Well, I was going to say also, don't use leased beats. You want something that you have control over, that's original and stuff. You're not doing this to fail. You don't want someone to Shazam the song and somebody else's song comes up because you guys are using the same beat. Stop using YouTube beats. Stop using all that stuff. If you go through like BeatStars or one of these companies or something like that, make sure that you are getting it exclusive. You're getting the stems. You're getting all this stuff. Like you're kind of wasting your time otherwise.
Question, if I am putting out a 9-song album, do you recommend that we copyright each song separately on both PA and SR forms? For the 9-song, the Copyright Office allows you to do a compilation. So if you have all 9 songs, just file it under that one album. So that way you only have to pay the filing fee one time. And then obviously if one of the songs gets infringed or whatever, you have the registration.
It sounds like you have a lot of songs for your album, and that is super fantastic. So on your rollout, what I would suggest is make sure that you're rolling out a couple of those songs first before you drop your album. You're not just dropping the album without nothing. We have tons of videos on this channel for music release schedules. But then I would also suggest you, because Spotify and all these streaming services, they count 7 songs as an album. I would recommend doing your album as 7 songs, keeping those 2 other songs to either release as like bonus tracks or singles after the fact. So it gives you a little more play in your release. So it extends that album release. So let's say you do 2 of those songs first. On the 3rd song, you drop the album with it. Now you're dropping visualizers with all of these. And then after you drop the 7-song album, you can release the deluxe version with the 2 extra songs on it. Or you can just use those as just extra songs that you're releasing. So I would definitely consider something like that since you have 9 songs.
Question, your song Monster is on Spotify. It shows up as Dukes Up Records, which is my company. True. Were you able to use Priam Digital? Yes. And have your label appear? Yes. And in fact, most of the distributors, when you go to distribute it, it goes who is the label or who is the owner. You can put the information usually in one of those categories. And so if you are running your own business, your own record label, put your label name there. What type of agreement should I have with another producer who wants me to remix his song, and what points or royalties should I receive? So you want to have, if it's with a producer, do a collaboration agreement on the split. It depends, are you paying? So if you're paying something and you're like covering someone's normal fees, I would say like you get 100% of everything, right? That's the way I would do it. But if you're not paying, or you're paying less than what this person wants, then you negotiate from there. If we're doing bigger deals, we'll be like, Mr. Producer gets like 3 to 5%. So just meaning a few points on the back end. But obviously you can do whatever you want to do. If you want to do 50-50 and you're giving the producer 50%, because it's just like goodwill. Half the time we're working together. No one's getting paid anything. We're just doing this because we like each other. And so if you do just 50-50 across the board, that's pretty standard for indie artist kind of collaborations.
But again, as your star, climbs and you start working with bigger names, those percentages are definitely on a different kind of scale because they're bringing all kinds of clout. So at the end of the day, also, it's how much you can bring to the table when you get to those bigger things. But absolutely.
Tom Music Attorney is your #1 legal resource for artists, producers, and record labels. Get contract templates, one-on-one legal advice, free master classes, and everything you need for your music business. Go to TomMusicAttorney.com. Question, even though you have a contract with the producer, will the sync licensee then take rights over the song for the sake of what they are using it for? So if you have a contract with a producer, if the contract doesn't say who has the right to administer the song, who is in charge of doing all of the things, put something new together. You can do an addendum to your existing contract or just sign a new agreement altogether. But you do want to get this in writing because that's what some of these shows will need to see to confirm you have the rights to do the thing. So for example, with my career and the producers I work with, the songwriters I work with, we might share ownership, We'll share profits. We might do all kinds of fun stuff. But I always say, I am the one that gets to make all the decisions in regards to how the music is placed, where is it placed, because it just makes it easy. And it's called one stop. When you can tell a music supervisor the music is one stop, meaning you are the one that has all the rights to administer it, then you're going to get the deal faster than someone else who's like, I gotta go check with the producer. I'm not sure if I can do this. So that's what I would do in that situation.
Yeah, definitely. And that's something that we have in place for everything that we do. And it should just be kind of standard language in what you're doing when you're working things out. Somebody has to control and make the decisions, but you have to have that written in the contract.
How do you vet a good lawyer for your local area? What should
Perfect
I be
question.
doing? Yeah, that's a really good question, Sam. I always tell people, I go, you got to go with your gut on understanding. Just because you go through the effort of finding someone and reaching out, it doesn't mean that they're the right fit. You know what I'm saying? And normally you're not going to find the right fit for you, because really when it's a lawyer, like an entertainment attorney who is specialized and understands what you need and what you do and the industry standards and all this stuff. Well, after you do that, you still need to make sure it's a good fit. It's a personality match. They know what the hell they're doing, because there's entertainment attorneys who had some things that they did like decades ago and they're not really with it. They don't know tech updates. They don't know what's going on. And it's not a knock. But I'm just saying that you need to make sure that the person that is representing you knows what they're doing. So for example, don't hire someone who's totally outside the field and be like, hey, I'm hiring a bankruptcy attorney, because they're, it's like my uncle. When it comes time for you to do a deal, that person's not going to know industry standard. They're not going to know what the main deal points should be. So you want to make sure that you take that time, do your due diligence. Obviously, I'm a fan of look at the Google reviews, right? Look at the Google reviews. And especially depending on what you're trying to do, if it's more transactional, you don't need to get someone who is local.
Sure.
Okay. So you can get someone, if it's helping with a trademark or copyrights or contract review, it's finding the person they think is a good fit for you.
And not to be intimidated. You know what I mean? Don't be intimidated by the process. A lot of times the first person that we Google that's got good reviews, we'll call them, we'll talk to them. We just trust them. We're just like, okay, you got good reviews, you must be good. They have to be a good fit. They need to speak your language. They need to understand you and where you're coming from, especially when you're looking at your contracts. This is where it is the most crucial. If you are doing anything with a record label, you want your entertainment attorney to understand what your goals are, what you want to have happen, long term, short term, so that you are represented. It's not just about industry standard. That's just a number. It's what do you want? What do you bring to the table? What advice can they guide you on to make sure that you are able to get the most value out of yourself?
DistroKid's parent company claims copyright against me on my Facebook video, against my song was their intellectual property. I've not found a lawyer interested. Well, not so much that, no. It's not that's not interesting. It's just that I literally had that happen to me as well. It's so annoying. And you have to reach out to the distributor and say, hey, you need to whitelist my social media profiles. Here they are, because these are my songs. This is my music. So it's an administrative step you have to go through. It's so annoying. But anyway, that's what's happening, because they're like, oh, we're going to collect all the earnings on social media. And then they're claiming it on your profile, which is annoying.